of State, who was here on my behalf. Unfortunately, the day after International Labour Day, he was gunned down by his own bodyguard. It will not be fair for him to make this statement when he was here last year before honoring him. And I want to invite all of us just for 1 minute silence to remember him. This is the late Colonel retired Charles Okelimono. Please, so listen to this. Thank you very much. I want to welcome Honorable Esther Nyakun to the ministry. The short time she has been here, she has already seen how busy she will be. I think she must have landed, I don't know whether yesterday, from Oman, where she was there for bilateral labor negotiation, and here she is. And every time there is a clash, but she's out of the task. I am honored to address the stakeholders that I see in the program, distinguished people who are supposed to come and discuss this matter today. And I want to recognize that labor justice traces its roots in the 18th century, where many workers in the USA and developed countries recognized the need to fight for their rights. Because at that time, people were working overtime. The condition for work was very, very bad. And so collectively, they gathered, they collectively realized that it is important to talk one language to demand for their rights. And based on that, the UN as a body, a global body, enshrined in its constitution the right to access to justice for workers without distinction, to provide for access to formal justice, dispute resolution, and mechanism to pursue remedy, including access to court. And that is why we have the industrial court, ably led by our sister who is here. And I want to thank you for the work you're doing in the industrial court. She's very passionate. I don't know how many times she has walked to my office on issues of industrial court, on issues of workers, demanding that we need to expand the court, asking for the need to increase the number of judges, pay an allowance for those members of the industrial court. So I want to thank you very much for the work that you're doing. Under the International Labour Organization, the protection of the rights of workers for collective pursuit of social justice underpins the principle that it is the state, the duty of the state, to protect labor rights through the exercise and permitting the exercise of collective action to enable freedom of association, including permitting the right to strike. I have not seen them strike back. That is an international principle, that you should allow them to strike if they want to, if their issues are not being protected. These are the rights. The articulation of the concept of access to labor justice, therefore, requires that states ensure that procedures are available to ensure effective exercise of those rights. You cannot talk about those rights when you cannot have the framework within which those rights are exercised. constitution, the Ugandan constitution guarantees those rights. The right to assembly, the right to disembark, the right, the economic rights. It is guaranteed. And in Uganda, the structure of delivering labor justice starts from the district, where the labor officers have the power to arbitrate and to mediate, to inspect and to offer remedies to workers. If that fails, there is another structure led by the Commission of Labor that has all the mandate to handle issues that have not been handled by the labor officers. Then we also have the Labor Arbitration Board that advises the minister. We have the Industrial Court that now deals with matters referred to them by the labor officers. Therefore, our labor law focuses on ensuring that the rights are protected, exercised, and remedies addressed. In Uganda, it is the labor justice law focuses more on the formal employment. And yet, under the statistics, majority of Ugandans are in the informal sector. So we need now to look at how do we also protect the rights of these workers in the informal sectors. Those of you who are seated here very comfortably, you have housemates, shamba boys. Some of you have family businesses, you have relatives you have put there. These laws do not protect them. So we need to look at how do we ensure that those in the informal sector also are addressed. It is true that globally, workers still face significant obstacles to access to justice due to weaknesses in maybe our labor justice system. For instance, there are weak administrative system and tribunals. When we talk about the labor officers in most of the district, the labor office is not well facilitated. They don't have a vehicle, not even a motorcycle, not even a bicycle sometimes. And yet, they are the ones who are supposed to sit and arbitrate with the powerful employer who has abused the rights of an employee. So we need to work to strengthen, and we are working to strengthen those administrative justice system. There is an amendment law that is before Parliament to handle issues to do with strengthening administrative justice system for workers. The issues around occupational safety and health in workplaces and handling disputes, the issues to do with accessibility to court, because the industrial court is only here in Kampala. What about all those whose rights are being abused in the 146 districts? They cannot walk if the labor officers have failed. Walking up to Kampala is not easy, but we are addressing it with the head judge who has made proposals on how they can be ensuring that they go where the cases have accumulated, they will take the court to the people. So I want to thank her for that initiative which we are working on. We look at issues of powerful employers who sometimes will not even allow the labor officers with the mandate to inspect. They will move to inspect and they will not open the gate for them. Those are the issues that are the obstacles that we need to ensure that we strengthen, and this discussion and dialogue will delve deeper to let us know what has worked, where, which country has best practices for us to ensure that we copy from. Through this convention, allow me to inform you that His Excellency the President has refocused us as government, as the Ministry of Gender, to ensure that we secure the future of Ugandans through job creation and inclusive development. Because we cannot start talking about labor justice when people don't have the jobs. The number of people who do not have jobs, the youth, the young people, even the older persons, are increasing every day. So His Excellency the President has refocused government in ensuring that we attract more investors, we create more jobs in service industry, in manufacturing, in other areas, so that first we secure labor rights that someone has a job. Secondly, to ensure that the job that someone has is a decent job. Thirdly, that the working condition is good, and therefore I want to reaffirm the commitment of government through the Ministry of Gender, Labour and Social Development to offer decent work for all in the context of this convention and the general government program. We are focusing on ensuring that we protect workers from unfair dismissal, ensure that we protect them so that their wages are paid, safe working condition, compensation of workers who get injured or incur diseases during the course of their work, ensuring that the workers and employers deduct Social Security and remit it. And I want to congratulate NSSF for the wonderful job they are doing to ensure that they reach out to everybody and address the issue of third-party contract, because other people are started trying to dodge Social Security and other obligations by not employing directly but using other companies to employ, and they will not be offering workers protection. I want to conclude by saying that we've made strides as government in creating an enabling environment where private sector can create more jobs. So we expect this growth to translate into more Ugandans having jobs, improvement in labor justice, and I want to assure you that in most circumstances, judiciary budget is not touched, and we are already negotiating that the industrial court budget should be among the budget that is not touched to allow them exercise their competence. So I'm looking forward to receiving your recommendations, your suggestions from the experts during this meeting, and I want to conclude by saying access to labor justice in our context is fully anchored in our Constitution with a foundational and critical promise that the protection and benefit of our laws are within reach to everybody, to all the workers, regardless of their wealth, status, race, and identity. Let us remember that justice for another and justice for many workers equals to very simple thing. Can I have a food on my plate? Can I pay school fees for my workers, for my children from the money I'm earning? Can I be able to get health from the money that I am toiling for? Can I have transport to take me from home to work and back to my place? Can I have shelter? Can I be protected by the law that if my employer fails to protect those fundamentals, can the state protect my rights? That is what we wake up every day to look up to ensure that the workers get those simple fundamentals. With that, I want to officially open your convention. Thank you.
Thank you so much, Honorable Minister. You made it very, 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 very clear. And if I could put it in the fourth estate's language, that I have freedom after speech. In that same vein, I don't want us to lose the tempo. Ladies and gentlemen, you'll join me as we welcome our keynote addresser today, Honorable Justice Nzioki Makau, the Honorable Justice of Employment and Labor Relations from Kenya, our keynote speaker to speak as the guest of honor students. You're welcome, sir.
Thank you very much. I am honored to be here to speak about an issue that has, of course, been touched on by all the speakers before me. Honorable Minister for Gender, Labor, as well as your colleague, Honorable Minister. I will write in the protocols that have been established so as to save on time. I wish to delve into the issue of the labor dispute resolution mechanisms and how it can navigate the future of work with an East African perspective, of course, with a bias towards Kenya since that time before. Dispute resolution is the process of settling disputes between parties. The history of dispute resolution in Africa can be traced back to the colonial era, but in the discussion with my colleagues from here, we have discovered that prior to the arrival of colonialists in East Africa, since we had systems of governance in countries such as the Pearl of Africa, there were means and methods of dispute resolution between workers and employers. You will agree all of us have either been employers or employees, and this is something that is traced back to the beginning of our interactions as human beings. Labor laws such as the Masters and Servant ordinances that were in place during the colonial era facilitated oppressive and coercive labor relations which were aimed at exploiting African labor. Unfortunately, in most of the countries that were colonized, any disputes arising from employment and labor relations greatly favored the colonizers, since African workers had no protection of their rights and no access to the legal system. For instance, in Kenya and Uganda, the European employer faced civil action, while African employees faced criminal sanction for work-related offenses. Furthermore, the colonial courts would not settle disputes between employers and employees within the labor sector because there was no labor contract between the parties, as the forced labor systems in place were slavery by all definitions. In the case of Kenya, the activities of trade unions led to the first tripartite engagement, which is the Industrial Relations Charter. This was signed in 1962, a year before our independence, by the Kenyan government and the Federation of Kenya Employers, the Federation of Labor, which is the predecessor of Central Organization for Trade Unions, Kenya. The Charter outlines responsibilities for the employer associations and unions in the matter of labor relations. And it is through that charter that the Industrial Court was established under the Trade Dispute Act. That court was subsequently replaced by the current Employment and Labor Relations Court, which is a specialized court, much in the mold of the Industrial Court of Uganda. So in this session, it is clear the relationship between the Ministry of Labor, I'll just call the ministries that are related to labor as the Ministry of Labor, the Central Organization of Free Trade Unions, the National Organization of Trade Unions, and the Federation of Uganda Employers are similar to the tripartism in Kenya, where the unions, employers, and government work in industrial harmony to ensure best practices and adherence to international labor standards. You've already heard from the ILO that there is a lot of collaboration that is available for Uganda in certain key key areas to ensure employee rights are respected and upheld. So labor disputes generally arise from non-compliance with the employment contracts, the unfairness in dismissal, discrimination, and various unconscionable labor practices, among others. When these disputes arise, they erode the employer-employee relationship. They affect productivity, as you've heard, to name but a few. It is therefore imperative that speedy resolution of labor disputes ensue so as to retain the flow of work. We all agree the effective dispute resolution mechanisms allow parties in conflict to reach a fair, effective, and speedy resolution. In the case of Kenya, we underwent a constitutional moment in 2010, and under the new constitution, a legal framework governing industrial relations, and a call to encourage, promote, and facilitate alternative dispute resolution mechanisms, which is grounded in Article 159 of our Constitution. The Industrial Court got a shot in the arm through the enactment of Article 162(2)(a), which established this court as a court of equal status with the High Court. The Constitution of Kenya was very progressive in that it had taken forward-looking positions which mirrored the labor laws in place. The Constitution allowed creation of two specialized courts, which is one to deal with employment and the one to deal with land and the environment. A specialized court is by design created to meet and address the needs of specific constituencies. In our case, it's employment, and it addresses unique jurisdictional issues. And this court has procedures tailored to their needs and a cadre of judges with relevant expertise. In Kenya, we are lucky, we have 21 judges. 21, not enough, but at least better than where Uganda is with only 2. I pray that Honorable Waziri, Honorable Minister, you will take that to His Excellency the President, so that you can expand the labor court, so that you can encourage the creation of various systems to allow for speedy resolution of disputes. Specialization is rapidly gaining momentum across the world, and that is attributed to the demand for access to justice for higher quality decisions by experts in respective fields. The introduction of our court has led to better decisions and has led to tangible results in efficiency through hearing procedures on the wings of well-trained staff and judges serving in the court. We have also had further reduction of case backlog by diverting cases from the general court through the reference of employment disputes to the industrial court. The general uniformity of decisions also has created jurisprudence to the extent that occasionally my brother and sister from Uganda will pick some decisions from Kenya to apply in various principles, the same way we pick from the two of them to apply to Kenya. In the East African region, courts are being encouraged to apply alternative dispute resolution mechanisms, which is often called the appropriate dispute resolution mechanism, but I heard today the Chief Justice of Uganda calls it African Dispute Resolution, ADR. That is the way to go, because ADR is supposed to be the main means of dispute resolution, as Article 33 of the UN Charter outlines various conflict management mechanisms that parties can adopt for dispute resolution purposes. It provides the parties to a dispute shall seek a solution by either inquiry, negotiation, mediation, conciliation, arbitration, and last in the list, judicial settlement, among other peaceful means of conflict resolution. Apart from promoting workplace harmony and long-term stability, effective dispute management procedures promote the right to access justice and fairness. So the starting point is that contracts of employment provide for means in which resolutions can be achieved, And then we have various conflict resolution mechanisms at the workplace. In Kenya, Section 47(2) of the Employment Act, which mirrors Sections 12 and 13 of the Employment Act of Uganda, provides that a labor officer presented with a claim shall afford every party with an opportunity to state their case and then recommend to the parties what, in his opinion or her opinion, is the best means of settling the dispute. It is all agreed that negotiation, mediation, conciliation, arbitration offer the best in terms of structured processes for resolution of disputes. So I'll go into the discussions in relation to the first avenue, which is negotiation. Negotiation is a crucial instrument in finding satisfactory solutions for disputes. Dialogue is key in ADR since the parties in the dispute initially engage in direct discussions with the goal of finding a jointly acceptable solution to accepting a mutually satisfying solution. The negotiation starts with parties talking about the grievance and complaints and then gradually follow the discussions on how they can achieve a solution. It is important that we note preparation is key, and that includes studying the situation, conceptualizing the consequences, and then setting the rules of engagement. Balance is needed when you are negotiating, and as such, when you fail to consider the interests of the other party involved, you fail. When negotiations are conducted in an atmosphere of trust and confidence, there is a higher chance for settlement. There are advantages in negotiation, which is that the labor conflict is resolved cheaply, fast, and avoids business losses because of the organized work processes. There is minimal disruption, and that is because parties are in control of their negotiation. Negotiations can cause standoffs when parties take hardline stance. Sometimes parties are left unprotected because of the risk of information leaks or non-compliance with the agreements. The other disadvantage is that not all the universally used means of resolving disputes, though being flexible and efficient, it is not often used, and that is because there are power dynamics as well as the inability of parties to compromise, which negatively affects negotiation. The second is mediation. Mediation is gathering momentum as a form of dispute resolution. As you may be aware, in Kenya we just concluded the second mediation summit. Mediation is taking a focal point, and it requires the participation of an impartial person who encourages the disputants to reach an agreement. The mediator helps the parties to determine and agree on the issues and establishes how they might be able to reach a mutually beneficial decision. The mediator is merely a catalytic agent and comes between the parties who are conflicting with the sole aim of helping them to reach a compromise. A mediator must be acceptable to both parties, and other than achieving a peaceful settlement, mediator should have no other interest in the dispute. It is kicked off with the initiation stage where the parties are both informed about the mission, the rules of the game, as well as the need to maintain confidentiality. And then finally, the parties are allowed to engage and then ultimately get to a position where they are at a settlement. If they disagree, that is not the end. There is an avenue through which parties can approach a court and continue with the effort to have their case resolved. In Kenya, we've had, in addition to these wonderful methods of determination, what we are calling court-annexed mediation. And court-annexed mediation is a form of appropriate dispute resolution which is done under the supervision of the court. Through the social transformation, through access to justice, which is the agenda of the Chief Justice of Kenya, we've been able to reduce backlog because we have parties referred by the court once we screen cases and determine that this matter does not need to have a judgment delivered and that parties can compromise the matter. We refer them to adjudication by a court mediator who is paid by the court and not by the parties. We are able as judges to encourage parties to go to mediation, and once we refer a matter to mediation, the mediator has 60 days within which to come up with a finding. If parties disagree, the matter is brought back to court and then we deal with it in the ordinary course. In relation to Uganda, I don't think you've established the court-annexed mediation. It's something we would encourage the court to do because I have heard you have 146 districts which require a lot of support, and the only way you can resolve disputes at that level is through a next mediation where you have a mediator, someone from the ministry, dealing with the parties at the ground on the district level and having a resolution of a dispute so that it doesn't have to escalate to the court. The judge in our case is the one who appoints a mediator. We normally don't name them, we just say this matter is referred to mediation. The registrar will be able to check on the list of mediators who are available and forward the file. We set deadlines. We say within the following 30 days there should be a preliminary report, and within 60 days there must be a final report, and then we wait for the feedback to come. Once that is done, we are able to resolve disputes. The only disadvantage we see is where parties question the selection of the mediator. Since we appoint the mediator by directing the parties to a court-appointed mediator, parties may think that it is the court making the determination, since they think we may have an issue of conflict as being the appointing authority. But so far it's been working, and therefore we would encourage that which will reduce backlog, reduce litigation costs, and accelerate the disposition of cases in the court. The next is conciliation, which is pivotal in settling conflict to return to equilibrium. In Kenya, the conciliation is through the ministry, and a conciliator is normally appointed by the Minister for Labour upon a reporting of a trade dispute. Ordinarily, the dispute will have to be determined by the conciliator within 90 days, that's 3 months. And if no resolution is achieved in the conciliation period, the matter is referred to court. When there is partial agreement, the conciliator will refer to the balance of the issues that resolved to the court, and we will determine the balance of the issue that remains. The final one is arbitration. And arbitration is a mechanism where parties are referred to a third-party arbitrator who is impartial to both parties and who provides a binding decision after listening to the parties' arguments and evidence. In arbitration, the disputing parties are not involved in negotiation and mediation. Decision-making is transferred to the arbitrator, who is sort of a private judge. And therefore, the parties are the ones who will pick the arbitrator, maybe through the Arbitration Institute. I know we have a chartered institute of arbitrators in Uganda. The chapter would nominate an arbitrator who will hear the matter, who will examine the evidence, and might be someone who is specialized in an area of practice such as construction. It could be an accountant, and then finally an agreement is reached and it is brought to court for adoption. The disadvantages of arbitration is that there might be substantial amount that is to be spent, on the arbitrators, as well as needing to engage advocates due to the complexities in the matters of arbitration. Sometimes arbitration may be less transparent than litigation. At times, when you consider the arbitration award, parties are at a disadvantage. In the final stage, I will look at the critical role of the judicial systems in labor disputes. As you're aware, the courts adjudicate on labor disputes, and the industrial courts have unique jurisdiction to address issues relating to employment and labor relations, such as protecting the rights of employees. And you've had the Honorable Minister speak of ensuring the harmony is maintained. Once the matter comes to court, sometimes it is difficult to maintain the harmony since our decisions are either one party will win and the other one will lose, or there might be a bit of a loss on one side and a bit of a loss on the other. But they are not as good as the other methods where parties are in control. Once the courts make a determination, our essence is to bring a determination on unfair termination to ensure there is more favorable treatment of workers. And even though I'm speaking on my behalf in the court in Kenya, as well as my brother and sister here, we have delivered fair and accurate outcomes in labor situations by applying the principles of fairness and justice, as well as the inherent constitutional safeguards which underpin labor disputes. As you heard from the Minister, the Constitution makes various protections available to workers who are the key wheel in the economy and the future of this beloved nation of Uganda. Once parties are concluded, once we conclude cases in our courts, parties have a right to appeal, and subsequently the appellate court may be able to give a determination different from that of the trial court. The good thing is that in Kenya we have now an opportunity to have judges of the employment court ascending to the Court of Appeal. The interview list for Court of Appeal judges came out yesterday. I'm one of the judges from my court who is on the list. There are 6 of us. We are all arguing for about 20 positions, and we hope that some judges from our court ascend to the Court of Appeal. In Uganda, I would pray that you skip the process of waiting for 20 years, 10 years, 15 years, and immediately start considering having judges who have experience in labor matters ascending to the Court of Appeal. There is the emerging trend which has brought some challenges, which is the impact of technology and the gig economy. In the East African region, technology has made a remarkable difference in how people get jobs. And I'm happy we have people who are tech savvy right here. And the rise of platform work has its challenges. Work arrangements in this sphere are typically short-term or limited in duration, sometimes in a freelance or temporary job which is made through online platforms. The concept of traditional employment has been irretrievably altered, and this ongoing development presents economies in the region with a mixed bag of benefits and drawbacks. Digital platforms offer diverse ways of earning through services like cab or ride-hailing services. People running their own business within sectors such as information technology, marketing, and content creation. This new way of work, including remote work arrangements, have liberated people from the constraints of typical job structures. This allows access to income generation options with great flexibility, regardless of location. While job independence is one benefit of developing in this sector, it mostly comes with little or no security. There are no social safety nets. As you've seen, we have NSSF here. NSSF deals mainly with the structured employment where contributions are made for retirement purposes. In the case of the gig economy, there is no formal structure of employment, and therefore there is no social safety net. There are no provisions made to access other services or advantages such as health insurance and pension. In the globalization that we all have experienced as a result of what happened a few years ago with COVID, we are more globalized and intertwined. There are cross-border work relationships, and as a result, multinational corporations, foreign investors, international institutions are operating between boundaries, which results sometimes in foreign nationals, expatriates, and migrant workers seeking jobs within the various labor markets. For example, such portfolios promote economic development and knowledge transfer. You'll all agree that if I get someone from Uganda coming to Kenya with a specialized knowledge in, say, production, our country and the industries there will benefit immensely because of the knowledge transfer that will take place. However, there are also challenges because we have to deal with work permits. There are sometimes regulations in immigration, cultural gaps, and legal jurisdiction. In the morning I was talking to Judge Wabire, and he mentioned to me a case where an employee came to work in Uganda for a multinational corporation which is both in Kenya and in Uganda. But after he served in that company, he joined another company but did not apply for a work permit, neither did his employer facilitate the application. So when his rights were, in his view, infringed, he went to the industrial court. How do you navigate where a party has refused to follow the laws in your country and has not protected themselves by seeking registration, and then they suffer a loss? So those areas for navigation are some of the things we have to deal with. And in that particular case, the employee, had that employee been registered or initiated the registration process, they would probably have been able to benefit from the protections here in Uganda. But having not complied with local law, it was one case where they would not benefit. In the same way, we have cases in Kenya where we've had work from various platforms such as Facebook, which are operated by employers who are not in Kenya, but the employees are in Kenya. And when there is conflict, we've had to navigate that space where we deal with international corporations which have no offices in Kenya but have employees. All these complex legal issues require a lot of investigation, a lot of research, so as to be able to come to the right position. The inclusion of cultural diversity, language and communication barriers need to be addressed in order to have an all-embracing workplace relationship. Finally, I'll deal with the issue of the online dispute resolution, which is a new and emerging dispute resolution option. ODR is supported by the internet and technology-powered processes such as AI, and is accessible through digital channels and assists parties in dispute resolution. It surpasses limitations like physical distance and logistics. For ODR platforms, virtual spaces are set up online where parties can undertake negotiations and other procedures such as video conferencing, communication between the parties, and the exchange of documents electronically. There are invariably electronic case management systems, and I'm happy to hear that the Uganda Industrial Court will receive support to digitize, because that will help in a quicker flow of work. I thank the Minister for making that option available, and I thank you for the support to the Industrial Court. Of note is always the data security and privacy issues, but I believe with proper safeguards and firewalls that can be done. So there are recommendations for employers to ensure that in the future or in the way of work that is current, it's important to have proper agreements in place, seek legal advice. The Uganda Law Society members are always available to help employers draft good contracts to ensure that you keep to the right side of the law. Ensure you have in those contracts safeguards for employee wellness, as well as alternatives for dispute resolution mechanisms, which include the African dispute resolution. In the case for employers, you need to also, sorry, for employees, they need to know their rights and their duties. You've heard it said here that there are certain rights that are inherent to an employee, but there must be an understanding of that right. And where employees have a challenge, they should seek legal counsel, because there is an increasing body of advocates who are skilled in employment matters. I met an advocate here this morning who is very, very keen in employment matters, and therefore with that growing list of advocates who are skilled in employment matters, employees can obtain legal counsel and must be encouraged to seek legal advice where there is conflict, so as to mitigate their losses and ensure that they are effective in resolving the labor disputes. Legal counsel enable individuals to fulfill their roles in protecting their interests and enforcing legal obligations, such as employee contracts. In conclusion, the successful resolution of labor issues in East Africa is of enormous importance, because if Uganda succeeds, Kenya succeeds. If Kenya succeeds, Tanzania succeeds. If Tanzania succeeds, Rwanda succeeds, and all the other countries in the East African Economic Region. As a result of speedy resolution, we are able to enable the region maintain an amiable and productive workforce. The balance between the rights of the employees and the employers can be achieved where the labor market and the investors have confidence. An economy that is free of strife will have greater productivity, which increases tax revenues, which the government needs to run its operations as a result of increased production. So if we take what has been said by the Minister, that His Excellency the President has a focus on ensuring there is a future for Ugandans to have employment, so that there is more productivity, so that businesses can invest, then you can see Uganda will grow and will have a future where the economy will continue to have an increase, since there will be growth in that sector. Countries in the region are experiencing a transition which was brought about by the globalization and the residual effects of COVID-19, which increased remote working arrangements. The employment space is morphing and causing employment relationships that traverse national boundaries to continue. We therefore need to adapt to the new challenges so as to be able to have resolution of the various labor disputes. Thank you, and may God bless the the Republic of Uganda. May God bless the Republic of Kenya and the East African community, which we all are members to. Asanteni.
Thank you so much, Honorable Justice, for that very remark. I saw my dear Minister taking notes of this at every layer, especially when you hinted about both judges. Our number versus the one of Kenya. She nodded and she tapped Honorable Esther, and I was like, this is home. Friends, just many of you who are online and those who possibly don't know who Justice Zioki is an alumni of Lewis and the Clark Law School, Oregon, the US, and he holds an LLM in Animal Law Justice, and still he has served as the judge of the Employment and Labor Relations Court of Kenya. His legal career includes the significant